and is with the Prison Policy Initiative, where she has worked in various capacities over the years. So what we have today is the opportunity to have both, or all three, a national, a state, and a local perspective. So at this time, I will turn it over to Aleks Kajsturn, and we thank you for being here. Also, for our participants, so you know, it's Aleks may need to leave a little early, so we do want to make sure that we have the opportunity for any questions to be directed in case that happens. And thank you very much, Aleks.
Great. Thanks for having me, and thanks for letting me head out early. So I'm very glad to see you all here gathered virtually today to talk about specifically women's incarceration, which is so often overlooked in criminal justice reform efforts. So women account for about 10% of people incarcerated in US prisons and jails. So patterns unique to women's incarceration are just so easily obscured when we focus exclusively on the larger overall incarcerated population. And so some people might be tempted to say, well, 10% of the prison population, that's not so bad. Why focus on that? So let's put that 10% in perspective. If you look at the world as a whole, 4% of the world's women live in the US, but the US accounts for 30% of incarcerated women in the world. And if you look at Virginia specifically, if Virginia were a country, it would have the highest incarceration rate for women in the world, surpassing even El Salvador, where women are still, routinely jailed for suffering miscarriages, for example. So this is kind of the level of incarceration we're looking at in the US and in Virginia. And so before I dive into the problems facing justice-involved women, I want to take a minute to talk about data. But first, to give a quick definition so that everybody's on the same page. So there are basically two kinds of correctional facilities that we talk about in the US. You have prisons and jails. Prisons in general are run by the state and hold folks who are sentenced to over a year. This is generalizations, it varies between states. Jails, on the other hand, are usually run by counties or municipalities, and folks serve less than a year or a year. And also, that's where you're held if you're incarcerated before trial. So now onto my point about data. Data is ridiculously and dangerously lacking for women's incarceration. For example, if you wanted to know the number of incarcerated women, so across federal, state, prisons, local jails, other agencies all together, that wasn't available until I did my own analysis of all the disparate data sets scattered across all the different agencies and published my findings a few years ago. And this isn't just academic. My analysis showed that nearly half of incarcerated women are held in jails. Now, this was a surprising finding, as it was common knowledge that most people are incarcerated in prison. As it turns out, most people is just most men. So the result is that for far too long, jails have been ignored by reform efforts because they play such a small part in males' incarceration. And so this has real consequences. Even though the overall incarceration rate in the US is falling, finally, women's incarceration is still growing in many states. So let's dive into jails for a little bit. 25% of women who are incarcerated have not been convicted. They're just in jails awaiting trial. So that's 1 in 4 women who are sitting in a cell today have not been convicted. And it's unlikely that all these women are held because they're a flight risk. The more likely explanations are that it's just harder for women to pay money bail. We found that women who were detained prior to trial earned about half of what women who were not incarcerated earned. So the median income for women heard pretrial was $11,000 per year. And of course, that's even lower if you're talking about Black women or Hispanic women. And it's well below the poverty threshold. And meanwhile, the median bail amount is set to $10,000. So you're looking at basically a year's income to get out on bail. And in terms of the gap, it's huge. Many women were just unable to afford bail as much as $500, which would cost about $50 for commercial bail bonds in states that still have those. And this has kind of a snowball effect, because the more you're held pre-trial, the more likely you are then to get sentenced, we found. And for women, the inability to get out of bail impacts their family as well. So most women who are held pre-trial are moms. About 2/3 of women held for bail of mothers of children under 18. And one study found that 40% of pretrial defendants said that detention had already changed or would change the living situation for a child in their custody. So let's take another step back and walk through some of the pitfalls that women face along the way through the criminal justice system. So you have recent trends in drug arrests, and just a note here. So recent in women's data is sometimes 10, 20 years old. This data is from the early, it's like around 2010-ish. But a lot of the data has been stopped collecting even with the Bureau of Justice Statistics. The latest breakdown for like nationwide offense types for women held in jails, for example, is from a 2002 survey. So the guesses we can make right now are all from aggregating data from across disparate systems. But so such as that is, women's arrests have been recently up across all county types. So you're looking at, this is over the last decade, women's drug arrests are up by 25% in rural counties, 23% in urban counties, and 26% in suburban counties. So you're seeing across the board increase in arrest of women for drug related charges. And you can see this on the flip side when you're looking at women who are already sentenced. 70% have struggled with drug abuse or dependence. So this is one of the areas where we see a connection between basically drug abuse, dependence, which are factors of other types of abuse, and women's economic standing in the US that filter down through the criminal justice system. And of course, as we talked, once women are arrested, they have trouble getting out on bail. Black and brown women make about 50 cents on the dollar of a white man, which is usually the kind of wages that bail is set to. So again, you just get stuck awaiting trial in jail. And you have double standards in society at large that are also a driving force within the criminal justice system. There was a case in Oklahoma that illustrated this pretty well. It was there was a woman who she had, I think, 2 kids. The boyfriend beat them up pretty badly. He got off with basically a slap on the wrist, and she was sentenced for child endangerment and was sentenced to many years in prison. And this is the kind of like standard that women are held to, basically, that permeates through the criminal justice system. If you look at girls who are incarcerated, nearly 10% are held for status offenses. So that's running away, truancy, and incorrigibility. And these are usually just responses to abuse at home that you get punished for and sentenced to through the criminal justice system. And once you're inside, you get harsher punishments and less tolerance than the men. you get the same kind of double standard for behavior as on the outside, but it's magnified with much more significant repercussions, of course. And because if you get disciplined, that impacts your access to programming, increases your time served, and of course, it's just more trauma that compounds and speed bumps to reentry. And women are often set up to fail. For example, you're issued clothes that are designed for men and then get punished either if A, your pants are too loose and they slip down, you have to hold them up, or B, you alter them in any way to hold them up. And basically, you have these systems in place where there's a baseline where you're going to fail either way, and the corrections officers are basically just have something hanging over you at any point. So any minor slip up will then be written up as something that seems like a problem. And when we talked about access to programming being delayed, women already have a much harder time getting access to programming while they're incarcerated. And this is because jails on the whole tend to have much less programming available than prisons. And you're looking at, because of the huge churn through jails, about 1.8 million women and girls get released from jail every year, compared to about 80,000 from prisons, just because you have so many people going in and out. And because of this churn, jails tend to have less programming available. And most women need these kinds of supports. Like we talked about, 70% have drug abuse issues. There's all sorts of mental health problems, lots of trauma from prior abuse, and serious psychological distress, which oftentimes for women is a holdover from before they were incarcerated, and then gets compounded by the conditions in prison, and abuse from the guards and so on. There's a warden of a local women's jail that I was talking to, and she had trouble getting programming. Like, they were having trouble getting the bids, even though they were trying, basically because some of the contractors said, oh, there's not enough women who are incarcerated for them to be worth providing the same programming that they were providing to the men's facilities. And for women, not only are you lacking programming, but the actual geographic location puts you in a much tighter place than for men, because again, there are too few women. There are fewer facilities, so you're more likely to get sent much further from home, which of course means you get less visitation, which then leads to loss of parental rights in a lot of cases, and that all again makes reentry harder. And again, the difference between jails and prisons, for women who are in prisons, we looked at just something as simple as the cost of a phone call. And in jails, we've found many examples across the country where you're paying over $1 a minute for a phone call. But even in states where it's kind of reasonable, you have
director of the Prison Policy Initiative.
Even in states where you have kind of reasonable rates. In Michigan, for example, you have 15-minute call from a jail is $22.
Local.
That same call from a prison in Michigan is $2.40. So that just adds burdens on the family, and families have a tough time coming up with that kind of money to keep in touch. And then on the flip side, then women have fewer ties that they were able to maintain while in prison. So you have a much harder time finding housing once you get out. 80% of women leaving Rikers, I believe it was, needed help just finding a place to sleep for the night. Wraparound services, halfway homes for women are much tougher to get spots in. There are fewer that provide the kind of services, and the demand is so high, you get sometimes 300 applications for just 12 spots. It's just really tough. And this gets tougher when, DCF or something like that is involved, because they require, let's say you have a boy and a girl, they'll require a bedroom for each, plus yourself. So all of a sudden you're out of prison, out of jail, looking for a 3-bedroom apartment. Like that is just real unattainable in a lot of parts of the country. And so basically, the reform efforts that have at least started to curb incarceration rates down are failing women. And most of it is because they're focusing on men in prisons. And so here kind of the summary of the problems. Women face greater likelihood of disciplinary action. And this isn't just the kind of anecdotes that I've given. Like they've been research, I think in Illinois specifically, comparing disciplinary action across the different facilities. There are just fewer diversion programs available. Oftentimes probation is billed as an alternative to incarceration, but again, you have incredibly steep fees that are often tied to probation. You have childcare duties that for women prohibit oftentimes successful probation, where you have to, they have required meetings with probation officers. Transportation is hard, particularly when you're trying to deal with your kids. And ongoing struggles with mental health and substance use disorders also just kind of means that more women end up as failures on probation and then get funneled back into the criminal justice system, into incarceration. And states continue to widen the net in criminalizing women's responses to gender-based abuse and discrimination. This is the overcriminalization of drug abuse, peripheral involvement in drug networks, mandatory dual arrests for domestic violence victims, increasing criminalization of just school-age girls' misbehavior, because again, you're just held to a much higher standard, as well as just survival efforts like running away. And of course, even among women, incarceration doesn't hit everybody equally. Black and Hispanic, American Indian, Native American women are disproportionately represented in the system. Lesbian and bisexual women are so targeted that they're more likely to be arrested than straight or gay men, which we tend to think of as a demographic, of course, more involved in the criminal justice system. And, just coming back to that point of 1 in 4 women sitting in a cell right now, as we talk, has not even been convicted yet. So that's the degree to which the US overuses incarceration.
Alex, thank you so much. I do want to give our participants opportunities for questions. I'll start it off if you don't mind. Where do things stand nationally on the actions to try and eliminate the cash bail system?
It's a mix, and yeah, basically bail in different states. That's the best I can say. Bail in different states functions differently. So it's kind of a quilt network of laws. But there are reform efforts to look at bail, not only for women, but not only because of the disparate factors, disparate impact, but it's a problem that funnels people into the criminal justice system overall.
And with regard to jails, as you well articulated, there are many more women in jails than prisons, and most of the jails, to my knowledge, were really designed more for men. Nationally, again, are there things that you have observed in terms of local jails and their facilities for women as opposed to their facilities for men? You talked a lot about the fewer programs that are available, but just in terms of facilities, what do you typically see nationwide in terms of availability of a cell for a woman in a local jail? And how does that compare with a man in a similar geographic area? I recognize that's kind of a broad question, but just as an overview.
In terms of, I think the kind of what I think that hints at is overcrowding concerns, and those tend to be a mix, just depending on the local facilities. I've noticed a lot of politicians using the lack of women's specific facilities and the conditions in the women's facilities to basically push for expanding facilities, building new facilities, which we know will then get filled. So that's, I think, something to be worried about in terms of when you're pushing for reform. You know, if the problem is a shoddy facility that doesn't meet your needs, the solution is not going to be a newer, bigger, shinier facility.
Alex, I'm going to interject that there's okay, it's already been answered. There was a chat box question that Claire will address. So
Yeah, I think, because that's
just
more
take that off. But anyone that wants to put a question, put it in the chat box for Alex.
Thank you, Michelle. That question that is in the chat box, I think, would be more appropriate towards either Claire or Areshini, because it does deal more with state rather than national. But if anyone has any other questions from the national perspective,
Yes,
Alex would be probably.
Sorry, I didn't mean to interrupt. There is a question.
Okay.
Are there any national groups that generally are more helpful to this female cohort? Are there any outstanding state programs of support that you like?
I think the one that comes to mind is there's a group working on, I think this is born out of the Bronx Defenders Project. They're working in Oklahoma, and they're basically focusing on women, providing counsel as they enter the criminal justice system. And I think those are the kind of, and on the flip side, it's a lot of formerly incarcerated folks that are working on housing for women on reentry. And those are the kind of, I think, direct service programs that I've seen most. In terms of having impact, of course, they're going to be small scale, but that's basic. Yeah, like if you look at Oklahoma, there was a very disparate impact of the way women were treated, and particularly, I think it was Black women were targeted in a certain part of town by the local authorities.
Thank you, Alex. Real quick, I'll do a look if there are any other questions from anyone. I don't see any hands raised. So out of respect of our time today, Alex, I want to thank you so much for being here today, for giving us a good national overview. And at this time, we'll turn the podium over to Claire Gastanga, the Executive Director of the ACLU here in Virginia. Welcome.
Sorry, I had to unmute myself. Well, thank you for inviting me. I mean, when we issued our report on women in the criminal legal system here in Virginia in the fall of 2019, we recognized, and Alex talked about this because I think it's just a given, that the over-incarceration of women is a symptom of a very complex network of social barriers, economic inequality, reproductive injustice, racial and sexual discrimination, all of which are deeply woven into our society, and they impact pretty much the full range of things that I'm going to talk about. I think one of the things I always like to make sure people hear me say is that one of the things that we all have to be conscious of is that the number one root cause of crime, whether it's committed by women or men, is what we choose to call a crime. And this plays out very much differently and disparately with respect to women. When we focused on the pathways in our report. We were more focused on the pathways to how you get into the system than we were focused at that time on conditions of incarceration or what happens after people get out. But our incarceration in Virginia of women was increasing more than double the national rate and 8 times more than the men's rate of incarceration. So in Virginia, it was a very specific problem. And we found that 3 of the 4 crimes that pushed women into the system, whether as juveniles or adults, were drug possession, larceny, and shoplifting. And all of those obviously were economically motivated at some level. And a lot of it was about supporting drug dependency. And yet we haven't looked at that from a taxpayer perspective and a service delivery perspective and said, well, if we want to decarcerate women, the number one thing we can do is offer better and higher quality drug treatment programs and stop treating substance abuse disorder as a crime and treat it as the public health crisis that it is and focus on providing services. I mean, it is still the case that even if you are a woman who is pregnant and you are drug dependent and you want to get off drugs for your sake and your soon to be child's sake, getting into a program is near impossible because the waiting lists are so long and it takes so long to get into a program that by the time you do, your whole purpose in doing so will have already come to birth, if you will. And so, we saw that there were lots of what we were seeing was consequences of circumstances, lack of access to quality jobs, which Aleks talked a little bit about, family instability, no access to drug treatment, and no meaningful protection against domestic abuse and domestic violence, which also are cofactors in many of the women who are in jail and prison in Virginia. Whether it's the criminalization of homelessness, the criminalization of substance abuse disorder, or the criminalization of mental illness, all of those things disproportionately drive women into the system and keep women in the system. There are a couple of good things I do want to talk about, though, because while we were disappointed that the governor didn't take us up on our recommendation to put together a working group to really study these issues and to come up with really strong recommendations to address things like the education and training of people of the system, to recognize that there are differences between the women and men who are entering the system, the increased investment of dollars in treatment, improved collection and tracking of data. Aleks is exactly right. We don't have enough data really to know as much as we should be trying to know about how to address these issues and how to decarcerate both our jails and prisons with women. Even on the pretrial side, we just don't have enough information on pretrial programs. We invited the governor to also have that group look at the laws that were in effect that disproportionately affected women and educational policies that disproportionately affect sending younger women and girls into the juvenile justice system. So we don't have enough data. We're not investing in the kinds of programs we need to invest in. Programs like Friends of Guest House in Alexandria, which is very good at working with returning women and keeping women who have gotten out of prison and jail out of the system. And Bethany House in Roanoke is another place in Virginia that's doing quality work on these issues. But we didn't have a chance to and haven't yet looked at all of the issues related to conditions of confinement. We think women may be disproportionately subjected to solitary confinement. We know that we don't have any meaningful mechanism in our prisons and jails to really allow people who are housed in those facilities reasonable ways to complain about mistreatment and get some kind of redress. Delegate Patrick Hope's ombudsperson bill and the study of that will be potentially helpful, but we need to watch that to make sure that it takes into account these special concerns with respect to women, including women's access to health care, women's health care, women's reproductive care, and also the potential for a better integration of women and their families through better visitation and ways that will maintain the family unit. Because Aleks is exactly right. Women in the system often lose their parental rights as a consequence of the way the system interacts with them, whether it's disproportionately difficult conditions of probation or the lack of really any kind of meaningful family contact, while people are housed in our jails and prisons. There is a little bit of good news though, because we did recommend some very specific changes in our legislation that criminalize different kinds of conduct. And some of that stuff is starting to happen. So for example, we had a law that said that the third time you're convicted of petty larceny, which could be larceny of a bag of chips, it's automatically a class 6 felony. Well, that was disproportionately felonizing women and introducing them into the prison system as opposed to the jail system. That law has been repealed. It was repealed effective in the 2021 session. And as of July 1, that law will no longer be on the books. And that will be a very good thing in terms of women's decreased felonization. On the marijuana side, going to Andrew's question, one of the other things that we advocated for was, frankly, we'd like to see decriminalization of all drug use and treatment, as Portugal does, of all drug use as a public health issue that needs to be addressed, not by criminalization and punishment, but by treatment and healthcare and public health programs. The legalization of marijuana will be hugely important for women particularly. And it's not just about making it not illegal to use marijuana as of July 1, but it's about a couple of different things. One is the way that our legal market's going to be set up. There's going to be a real effort to introduce social equity into that market in a way that potentially has the potential to give women additional access to good economic opportunities in the context of the development of that market. But it also does mean that women will not be subject to criminalization for use of marijuana as of July 1. Now, there's a problem with the bill, and hopefully when it comes back to be reenacted, there'll be some additional changes we can make. It does, unfortunately, criminalize kids. It says that children that have marijuana that are caught with it at school, it's a class 2 misdemeanor. If they're in possession any other time, it's illegal, and they will be adjudicated delinquent, which in juvenile crime speech means made juvenile criminals. And every child who intersects with our juvenile justice system has an exponentially higher potential for being an adult offender than if they don't interact with the system. So folks at Rise for Youth and others in the advocacy community are going to continue to work really hard to try to decriminalize marijuana with respect to kids as well. We advocated in our report for an increase in what's called the felony larceny threshold. Our threshold was $500, which meant if you stole a used iPhone, you would be a felon and go to prison as opposed to jail. And as of 2020, our felony threshold was increased to $1,000. We wanted it to be $1,500 or $2,000. We'll get there eventually, but $1,000 is better than $500. And remember that anytime you get convicted of a felony, no matter how small a felony, it's a felony to steal a $5 chicken in Virginia because the poultry industry values their chickens so highly. Anytime you get convicted of a felony, you lose your voting rights for life until we fix that with the League of Voters' help by making voting a fundamental right that's constitutionalized, which I hope we'll do on a schedule that gets us to the ballot to get voters to agree that that's the right thing to do in 2022. Expungement, we really think that if you're really serious about trying to create an opportunity for people to return to being constructive people in our communities, that you have to, at some point, be able to erase your record. We are moving in that direction, particularly with respect to the drug offenses. And I think in the longer term on all criminal offenses, other than a very discrete small group like capital murder. We recommended in our report that we need to do something about the fact that Virginia was one of 2 states where juries still sentence people, and juries were sentencing people without the sentencing guidelines, which meant that they were likely to impose much higher penalties. And the reality was that we were, in 2019, only 1% of felonies were tried to a jury because people were so afraid of that kind of adverse consequence of exercising your right to a jury trial. The good news is that in 2021, our legislature agreed to repeal jury sentencing in Virginia. We had recommended some changes to fix it. I'm really happy they just went ahead and said, no, that's not going to happen anymore. Unless the defendant wants the jury to do the sentencing, we're now going to be in a position where the judges are doing the sentencing with the guidelines. But that means we need to go back and look at the sentencing guidelines to make sure that there's enough in there that helps them understand the difference in the way women present in the criminal justice system, in the criminal legal system, and that ought to be something that's taken into account in the guidelines. And that's not the case now. We have had some increases in pretrial diversion, and the really good news is that we've now repealed, as of 2021, all of our presumptions against bail. So there were a whole series of things that if you committed certain crimes, it would be presumed that you shouldn't get bail at all, that you should be held regardless of whether you were a real objective danger to the community. We've now repealed, as of 2021, all of those presumptions against bail. Now, do we still have cash bail in Virginia? Yes. Are we moving to trying to substitute a more thoughtful pretrial diversion that basically says, you know, folks shouldn't be in jail if they're not a danger, direct danger to other people? Yes. But there are issues around how you evaluate that, and we're going to have to continue to fight for reasonable pretrial diversion. Look, in Virginia, if you are observed by a police officer to be committing a misdemeanor, you're supposed to be released on a summons unless the officer decides you're a danger to self or others, won't stop doing the criminal act, or won't show up for trial. The fact is, too many people are not released on a summons or taken down to the jail, and too many of those people are women. And so increased use of the law that says you're supposed to get a summons on a misdemeanor and get released pending trial, would benefit women. So we need more data. We need to move to thinking more directly about conditions of incarceration, things like the ridiculously high telephone charges, whether pregnant women are still being shackled in violation of the regulations that exist that's supposed to prohibit that, whether we're really looking at women as the primary caregivers when they're arrested. Many times they're the primary caregiver in their family, and their arrest has a cascade effect on their entire family. There are a lot of things that we still need to do, but we've made a little progress in changing the legal framework that we're operating under. And hopefully that will begin to show some benefit in the reduced increase in the rate of incarceration of women. So I'd be happy to answer any questions.
Claire, thank you. And as you saw, there was a question earlier in the chat, and that is, when marijuana is legalized in Virginia this summer, any idea how much of an impact that will have on the number of drug-related charges there are or will be regarding women?
Well, there are some, it's hard to estimate, in part because they put so many new crimes in this bill that in and of itself is a concern for us. Keep in mind, as of July 1, it will be legal to possess marijuana under state law, but it'll still be a federal crime. Keep in mind that it will be legal to possess marijuana up to an ounce on your person, not in public, but you will have no way to acquire it. there's no legal way to acquire marijuana. So if you acquire it, you would be, whether it's importing it or whatever. Yeah, I mean, so we are decriminalizing the possession itself, and we're allowing people to grow up to 4 plants in their homes, but there's no legal way to acquire it. And there are all these additional crimes that have been put in place, like you can't have marijuana in your car. And it says that you can't, it will be presumed that you're using it in your car, which is illegal, if you have it in an open container. And the only thing that's not defined as an open container is the original manufacturer's packaging for legally sold marijuana. Well, since there's no legal sale until 2024, there's no such thing as a legal package. So even if you had marijuana in the passenger cabin of your car in a sealed mason jar with candle wax on the top, it would be an open container under the statute. And so there are all these different issues that we still are trying to iron out about criminalization of marijuana. But it is good that the police can no longer arrest you for possession. That will have a salutary effect because women are subject to disproportionate incarceration on drug-related crimes. They are often put in a position to be arrested for possession with intent to distribute because their significant others ask them to hold drugs in circumstances in which they're not actually directly involved in the sale, but their partner is. So there's lots to work out. So I wish I could tell you, Andrew, that there will be a X percentage reduction in drug-related charges for women. I don't know that I can say that, but I can say that, taking marijuana out of the illegal classification should help with decarcerating women eventually.
Thank you. We have another question. What is the data on the involvement of weapons by women to commit crimes? And what are the most prevalent reasons for arrest and conviction?
Well, Alex may have some national data that would be helpful. But as I mentioned before, 3 of the 4 primary crimes that women end up in our system in Virginia are drug possession, larceny, and shoplifting. Rarely any of those committed with weapons. And so, the other area that comes up a lot is sort of response to domestic abuse and domestic violence.
Thank you. And Alex did post a link towards some national data on the breakdown of offenses. Claire, you mentioned that effective July 1st, the Virginia will no longer have what in the military we often refer to as an accelerator clause, where the 3rd time of a minor offense results in it being a felony. Will there be any sort of retroactive relief either for that or for marijuana? Is there?
No.
I'm sorry.
Yeah, it's prospective. On marijuana, there is going to be a system that's set up that allows people to ask for release, so that people who are in our system because they were previously convicted under the old laws can ask for a reduction of sentence. But it isn't clear yet exactly how that's going to operate, but that will be something that we're doing a session at the Virginia State Bar in June called Marijuana 101, because the whole legal system and all of the defense lawyers and all of the lawyers who work the system are going to have to understand all of these things, and both expungement and this request for reduction of sentence are going to be systems in which it's going to be very difficult to navigate them without some kind of legal help. And Alex mentioned something happening in Oklahoma that we're talking about in Virginia too, but we're talking about it for everyone, which is making sure people have a lawyer the first time they show up in the criminal court. Currently, you can go to court, you can be held without bail, or you can have bail set in a circumstance in which you haven't been signed a lawyer yet. And we're working to make sure that everybody has access to counsel at their first interaction with the system, which we think will help keep people out of our jails, particularly pending trial. Look, you know, we all say that people being held pending trial are innocent until proven guilty. And yet we treat them as if they are guilty and they have to prove that they're innocent. And so anything we can do, 45% of the people in Virginia jails continue to be people who are not convicted of anything. And a disproportionate number of women are in that category. So we need to really work on our system to make sure that we use our summons systems so people get summons as opposed to incarcerated. We need to make sure that we have a pretrial system, diversion system that works, and we need to get people lawyers when they show up in the criminal system for the first time so that they can advocate for themselves effectively. I mean, look at what happened with capital murder in Virginia. Once we taxpayers paid for a capital defender program, no person was convicted of capital murder in the last 10 years, which is part of the reason why we were able to move toward repealing the death penalty. So it is absolutely a fact that having good quality counsel makes a huge difference. And Virginians understand that our system works differently for people who have money and can hire lawyers than for people who don't.
Mhm. Clara, I would like to circle back a little bit. So it sounds like as regards marijuana, the system will provide a process for those who previously had been convicted to be able to have their case looked at again. And you indicated that for these other, the multiple offenses, that the third one results in a felony. There is no system in place. Is there any other mechanism where someone who has only been convicted under those circumstances, no other criminal offenses that would have resulted in this, what, if any, mechanism or process is even possible for someone when we change the laws? None. They're just stuck with the same.
Yeah, no, unfortunately, unless it's specific that the legislature has made something retroactive, it's always considered to be prospective only.
Mhm.
Now, one hopes that people who have these kinds of convictions on their records will have an easier time of getting those convictions expunged down the road. And, you know, Virginia was dead set against expungement. I mean, if you said the word expungement in the legislature up until the last year, essentially people would laugh you out of the room. The idea that our legislature would consider setting up a system in which people would, you know, one day live beyond their worst day when they did something wrong and got convicted. You know, so I'm really excited both about the expungement system that's being put in place on the marijuana laws and the opportunity it's going to present for us to continue to argue that it's just not right for people to continue to carry records around that reflect a crime that no longer is a crime.
Let me check to see if I see any hands up from any of our other attendees for questions. I don't see any. I have another question for you, Claire. Pregnant women who are stopped by law enforcement, are drug testing procedures different for men and women? And secondly, are women who are pregnant at greater risk of additional charges as regards the potential or an allegation of harm to their child that a man would not face?
Well, you know, we've had some, we've been involved in some cases that reflect that kind of thinking in circumstances in which judges have held women pending trial who they perceived to be drug dependent, and you know, in one case the person was actually taking a methadone related drug to try in a supervised program, and she was prohibited from continuing to take that and held in a jail instead of being allowed to continue her rehabilitation. So, I mean, we do see that come up where prosecutors, we've seen it mostly in the Valley and in rural parts of Virginia, where prosecutors and judges have wanted to criminalize pregnancy for women and use it as a reason to incarcerate somebody who was not a danger. It's something that we continue to look at. And I think it's something that all of us need to be sensitive to the reality that that there's a social and political bias that comes into play then that devolves to the detriment of pregnant women who get caught up in the system. And many of them get caught up in the system because of substance abuse disorder. And many of them are people who would have taken advantage of a treatment program if it was available. Instead, they're in jail.
Claire, have you had an opportunity to form sort of an observation of how the Virginia courts have responded to situations where a woman or a girl has been a victim of domestic violence and reaches a breaking point and responds perhaps with violence? Are they treated as victims, or is it?
Well, I don't want to generalize, but I will say that, Virginia does have a primary offender requirement. Many years ago, I think it was during the Gilmore administration, we passed a law that, again, some folks might raise some questions about how well it's worked or whether it was the right thing to do in light of current circumstances. But we passed a law that said in every domestic violence situation, there must be an arrest. And the police are supposed to arrest the primary aggressor, because there was certainly a point in time when they would intervene in these and just arrest everybody. And file charges against both parties. That still happens. And I think if you talk with the folks from Virginia Sexual and Domestic Violence Action Alliance, their concern is that we spend a lot more time on the punitive side instead of on the preventive side of these issues. And I do think that there are all kinds of biases built into the system when the issue is family abuse or domestic violence.
And Claire, when they're both arrested, and I don't remember the statistics.
Well, they're not supposed to both be arrested anymore, but it still happens.
But if a woman is arrested, with a high percentage of women who are mothers who have minor children at home, what I'm clearly hearing is the consequences of that in terms of potential loss of parental rights, housing, and everything. Was there anything more that you wanted to add in that area?
Yeah, other than to say it has a cascade effect and the system doesn't think about it, doesn't take it into account. But, I'm not a prosecutor, so I don't, and I'm not a criminal defense lawyer, so I don't do these cases every day, all day, like some of my colleagues in the system do. And I would hope that our other panelists may have some experience directly relevant to that question as well. But we tend to look at it, sort of from a very high level. And when we did our report, certainly we said, this is something that people do not factor in, whether it's the sentencing guidelines, whether somebody should be held pre-trial. We don't factor in those issues in a way that we should, nor do we factor it into our visitation policies, our cost of phone calls, whether there's video phone access, all of those things. We don't factor family preservation into those decisions, and we don't factor in the recognition that in many circumstances, in a majority of circumstances, the primary caregiver is the woman who's being arrested.
Claire, thank you so much. Your information has been so helpful. And
well, Donna, your questions have been provocative and made me think, and I appreciate every one of them. They're great.
Well, thank you for what all of y'all do. And now, Areshini, we've set you up for all of the local questions, which I know we're going to have many of, because we've had the national overview, the state perspective, and now for those of us here in the local area, we really are looking forward to hearing from you. So we'll turn it over to you.
Perfect. Thank you. I'm going to try and get my slideshow going here. Hold on one second. Okay. Hopefully everyone can see the slideshow. But my name is Areshini Pather. I'm a prosecutor in the Charlottesville Commonwealth Attorney's Office, and thank you so much. I'm so honored to be sharing the stage with all of you today, and as well as our two amazing presenters. So this is just going to be an overview from my perspective of women in the justice system, women in jails, women in prisons, and my perspective is as a prosecutor, but I also was a public defender in the city of Richmond for 6.5 years. So the place that I wanted to start is, I think, a place that we've been talking about throughout this, and Alex has mentioned it, Claire has mentioned it, but I really do believe that we have got to look at ACEs as a criminal justice system. We have educated ourselves in our office, and it's primarily because of conferences we have gone through, but ACEs are called adverse childhood experiences, and I'm sure there are a lot of people on the call who know about them, but why I wanted to ground our talk in this is that I think there's a relationship between ACEs, trauma, and going into the criminal justice system. And Claire talked a lot about prevention, but that's what I think ACEs answers. So basically what's on your screen, and I'm going to be mindful of the time because I know this is supposed to get done at 3, so I'll run through everything really quickly. But ACEs are adverse childhood experiences, and these came up in a study by Kaiser Permanente, which is an insurance group, but they wanted to look at what was happening with a group of women in terms of childhood exposure, and what did that lead to in terms of experiences in later life. And so on your screen, you see just how wide the childhood experiences can be in terms of the impact on later life. And we know these to be physical impacts on later life. We know them to be well-being, but for our talk today, I think we also need to think about them as trauma, and how, if we look at trauma as a criminal justice system, hopefully what Claire was talking about, we prevent people from entering the criminal justice system. I think we all know this. Women and children, I just use that in this example, are at high rates of being victims of intimate partner violence and sexual assault. And for a lot of them, they remain silent. And what happens when we remain silent about something that has happened to us? We might start using substances to cope. We might have an untreated mental illness. It might manifest in a lot of different ways. But I think if we look at trauma as an entry point into the criminal justice system, it's a way of thinking about it. And I think especially for our women in the criminal justice system, especially for our girls in the criminal justice system, there might well be adverse childhood experiences that we're not acknowledging. And in the slide on the right, this was the study by this one organization, and it had 17,000 participants, and over 60% of them had at least one ACE. So we know by that there's a prevalence in terms of this in the community. Okay, so I'll just go to the next slide. Again, this slide is just going to talk about what does ACEs do when people have ACEs. And I think the important thing is, it's not just about counting the number of ACEs for someone, it's about saying, how do we as a society, how do we as a community, how do we as a criminal justice system build in resiliency? Because that's what we need. When someone is facing a trauma, how can we build resiliency in? But we can see that all of these challenges, like in households, in terms of abuse and neglect, can lead us to having more than one ACE perhaps. And then on the slide on the right, it shows us what the adverse childhood experiences can bring. And I do believe a lot of this comes back to trauma. And I just want to address one thing that Claire mentioned in her answer. You know, one thing that we have looked at locally, and Alex talked about this as well, is dual arrests in intimate partner violence and domestic violence cases. And what we have done in Charlottesville locally is train our police in terms of that there shouldn't be a dual arrest. And as Claire said, the law in Virginia is who is the predominant physical aggressor. So who is the person, based on talking to witnesses, who is the person who you believe there to be probable cause has caused this crime. And why I think that's an important way of looking at it. It can't just be a grab bag of going on scene and arresting everyone who is in there, because that's going to bring women into the criminal justice system. And I would just say one more point on that. Virginia legalized strangulation recently, and oftentimes in strangulation, and we see women are predominantly the victims of strangulation. And 2 points on this. One, studies have shown that if you are a victim of strangulation, you are at 70% greater likelihood of a lethality event happening just by that relationship. And so as a result of that, in Charlottesville and Albemarle, we introduced the LAP, which is the lethality assessment protocol. So this connects anyone who is a victim of intimate partner violence or domestic violence immediately with an intake shelter worker if they screen in for that. And that's really important. But the other thing that we have done is trained, because oftentimes, and I think this is what Alex and Claire were getting at, if you defend yourself, it's going to look like you are the predominant aggressor, you are the primary aggressor, because Virginia doesn't recognize battered women syndrome. We are looking at traditional self-defense. And we oftentimes know that when women have been victimized, they might act out physically and it might not look like self-defense in terms of what the laws in Virginia say. So we've got to be attuned to, like, say, for example, if a woman like scratches to get someone off of them, it might not be that they're committing an assault. It might mean they're trying to defend themselves and prevent a greater harm from happening. So again, that's part of what we have done locally here. Okay, the next slide, and I'll move through this because Claire actually stole a lot of what I had to say, so this is going to be repetitive, but I am employed by Joseph Platania, who is the Commonwealth's attorney for Charlottesville, and Jim Hingley is the Commonwealth's attorney for Albemarle County, and these are two localities that work very closely to each other. They formed Virginia Progressive Prosecutors for Justice, and you've got all the named prosecutors on there. And Claire talked a lot about what I'm going to go over in the slides, so I'll keep it very quick. But why I thought this was important to bring to the group is that the criminal justice system is not monolithic. It is different district attorney's office, different Commonwealth's attorney's offices, with different views and different policies. And this group banded together because they knew that there would be power in terms of their legislative ability and their ability to affect change. So here are just a few of the things that they did. In March of 2021, they sent a letter to House leadership, and they basically said that we are a reform-minded group of Commonwealth's attorneys, and we represent over 40% of the population of Virginia. And here are some of the things that we would like to bring to your attention. And I think, as everyone knows, in Virginia, we've had some very significant legislation come out of the 2020 special session, and then our general session in 2021, and then the current, and then the special session as well. So let's see, hold on. Here we go. Sorry. Claire's talked about this, so I'll move through it very quickly. But one thing that they talked about was the abolition of the death penalty, and I won't spend too much time on that. But what I wanted to talk about as well was expungement, which is what Claire did touch on again. And Virginia has expanded expungement a lot. Our office joined in support of legislation for human trafficking victims to not only expunge their records, but to vacate their criminal convictions. And there have been a lot of steps generally in the right direction. And so Claire's already talked about this, but this is one of the areas that have been signed on. And now there are, at least in place, a number of petitions that are available that weren't available before, in order for people to expunge their criminal convictions. It's complicated, and so I won't go into all of the details, but I think the salient point in this one is that we're making steps in the right direction, and the expungement of criminal records was definitely a focus of this group of prosecutors. Claire's talked about this, and I'm not going to spend a lot of time, but when I started as a public defender, the larceny threshold, meaning the threshold that takes you from a misdemeanor to a felony, was $200. And you can imagine it's really easy to get to $200. It is not difficult at all. So then we made the next step to $500, and then we made the next step to $1,000. And now we're at a place, as Claire's mentioned again, where the 3 strikes of petty larceny are no longer going to be considered a felony. So in Virginia, you could steal, I'm just making this up, but like a bag of chips, get convicted, a second bag of chips, get convicted, and a third would be a felony. And now this is 0 to 5 years in prison. But what this law has done is abolished it across the state. I would like to bring just one point, and it comes back to my earlier point of the justice system not being monolithic. In our office, we had, with our discretion as prosecutors, before this law was passed, to reduce the felonies to misdemeanors in general district court. However, now post July 2021, that is no longer going to be the case. Okay, 2 of these things, and they have been mentioned here, and I won't spend too much time on them, were mandatory minimum sentences. And so the ACLU and many allied stakeholders have spent a lot of the time in the General Assembly, and Aleks talked a little bit about this, even though the focus is more on jails for what we're talking about today. But I would just say be mindful of this area of criminal justice reform, because there was a lot of talk about it in the General Assembly in terms of ending mandatory minimum incarcerations. And what a mandatory minimum is that if you are convicted of X offense, the judge or the jury, and we don't have jury sentencing now unless the defendant asks for it, but you have to be sentenced to a specific term. The judge, the jury, whoever is making that decision does not have discretion. So third, I'm not making this up, but third distribution would be a mandatory minimum of 10 years of incarceration. So you can see how quickly these can add up. That hasn't been passed in the General Assembly, but I do bring it to your attention because I think it is the path that they are going on. The second part is what has been talked about first by Aleks in terms of what we see in jail populations, and second by Claire, is the ending of cash bail. So basically what cash bail means is that if you are arrested for a misdemeanor or a felony, you go before the magistrate or go before a judge and they say you have a bond of $7,500. And typically what would happen is you'd have to pay 10% to a bail bondsman to bond you out. And so again, with the examples we've been using, you can see how quickly this adds up. Who has access to $750? Who has access to even pay the whole amount? One thing we've had in Charlottesville for many, many years, and that is thanks to Dave Chapman and Joe Platania, is that we do not ask for cash bail. Our judges don't give cash bail. The magistrates operate under a different system because they're independent, but we are not a locality, neither is Albemarle County, that's going to ask for cash bail. What we're going to focus on is releasing the person if they're not at a danger or a risk to reoffend or at a risk of failing to appear. Usually they'll be connected with pretrial services pretty immediately, but we're not a jurisdiction that's going to say you need to pay in order to get out of jail. And so already, hopefully, this is taking people out of the number that Aleks was talking about in terms of the pre-trial detention number. Okay, the next group I'm going to focus on is fair and just prosecution. And I bring them to your attention because I think the work that they do would be interesting to your group. They are an allied group of newly elected prosecutors, and they basically connect people together. And oftentimes they take a particular stand or support in favor of an issue or against an issue. And just some of the issues that they're interested in are the issues we've been talking about today. So alternatives to incarceration, community prosecution. We haven't talked about restorative justice, but thinking about collateral consequences, which is what Claire talked about, like immigration. What are the consequences going to be if you're a green card holder or if you're here on a refugee status? And then expungement, which we have talked about. So I wanted to put this up on the screen, and I think there's just been a lot of overlap in terms of what we've been talking about. But this here is a fair and just prosecution letter from 2020, and it was signed by over 70 elected prosecutors throughout the United States. And what it was saying that is that even if the Roe versus Wade protections are overturned or limited in the states, and we know that this can happen in terms of access to abortion or access to reproductive freedom decisions, some of those decisions can be criminalized by various state governments. But these were 70 prosecutors who said they would not infringe on the person's right to make that decision about their autonomy or a medical provider to provide that. So I thought that that would be interesting to the group because I think it shows what happens when there's strength in numbers and there's 70 prosecutors across the United States who signed it. And Joe Platania was one of the signatories on this. The second one just came out recently, and I know Andrew's on here and there's an NBC 29 article about it. And this is exactly what we've been talking about today from the beginning. But this was a letter that they signed, and it's signed by Joe Platania in Charlottesville, Jim Hinchley in Charlottesville as well, just locally, as well as a number of prosecutors across the United States. But it's a call to action in terms of mass incarceration. And it's talking about lengthy sentences and what different prosecutors can do about it. And in terms of what can be done in terms of looking at what does the research tell us, what is the evidence-based decision-making in terms of long periods of incarceration. And that's precisely where we started at the call today, or the webinar today with Alex, in terms of longer incarcerations that are impacting women. Okay, so again, I'm gonna move through this pretty quickly, but again, these are some of the local initiatives that we have done. We don't prosecute prostitution-related offenses. What we have in our office is supervisor approval for your first felony conviction, meaning is there an alternative that we can consider for someone before they become a felon? And the case might be taken under advisement. Maybe there's substance abuse treatment, maybe there's mental health treatment that can be done. We have talked about cash bail, but again, that is a really important key so that people are not having to pay money to get out of jail and back to their families and back to the support that they have in the community. Pretrial services are services that go along with having a no cash bail. So someone is connected with a pretrial supervisor. Post-trial supervision, I think, is an important place to talk about. There's been a lot of change in the General Assembly this year in terms of the number of people, and this is for both men and women, convicted of probation violations. And I think if you go back and look at Alex's initial slide, or the paper, excuse me, you will see the number of people who are incarcerated both locally and at a prison level in terms of probation violation. The General Assembly has put in a lot of legislation on that point, and that will soon change. And that's thanks to Claire and many allied stakeholders like that. But I will say one thing that prosecutors can do is shorten the term of probation. Sometimes it would be people would be on there for a long period of time. And you can imagine that that is just going to exacerbate an issue. So if someone needs help, if someone needs substance abuse services or mental health services or something like that, let's tailor it to the individual instead of having a universal monolithic approach to everything. We've talked about the LAP, so I'm not going to talk about that. One thing I will also say, and again, this is just another example of alternatives to incarceration, is that when COVID hit our office, like many other prosecutors were faced with what to do with people who are incarcerated. And we know that if you're in a congregate setting, the risk of getting COVID is much higher. So there are tools available, certainly in Virginia, and one of the tools that we used a lot of was home electronic incarceration. It is free. The person can be at home and you're taking them out of a congregate setting that might likely result in exposure to COVID-19. I think at our jail locally, luckily, we have not had that. And this has dramatically reduced the number of people. Okay, my last slide is this, and it's just about access to information. So recently in the General Assembly, we have expanded discovery rules, and discovery is the access to information. So it's the police report. In Charlottesville, the city of Charlottesville, our police wear body-worn cameras. And so that's really important in terms of access, in terms of transparency, in terms of people being able to see it. And so I wanted to mention all of those things because it's important to know that, you know, before there have been these reforms, a defendant's access to getting information, meaning how do I know what I'm charged with? How do I know what the government has? Could differ in a different prosecutor's office. And so we've always had what's called open file discovery, meaning that the defense attorney will have access to the file, including all of that information on screen. Okay, so I just wanted to talk about diversion. So the General Assembly has expanded diversion. What diversion is basically is taking a case under advisement. And so before the changes from the General Assembly, there were certain changes like possession of drugs, where you would be on probation for a year, do 100 of community service hours, comply with probation. At the end of a year, the charge would be dismissed. Now what they've done is something our office has done for quite a while, to say, look, is there a way to take this case under advisement so that someone is not becoming a felon, someone is not serving a long jail term? And again, that's just a really important alternative to incarceration. One thing is I wanted to mention as well is specialized dockets. These are really important. We have a drug court in Charlottesville, Albemarle, which was one of the earliest ones established in the state. We recently introduced a therapeutic docket that helps folks who are suffering with mental health diagnoses, and these are common throughout at least the Commonwealth. And we also have what's called a family treatment court. That's not criminally related. That is an alternative court based in our juvenile justice system. But in terms of what we're talking about as folks and moms who are substance abuse and they want to get their kids back, the family treatment court is a great court for that. And so I've talked about limited probation terms. And so with that, I'm sorry that I went over because it's 3:19, but that's where I am. And so I'm happy to answer any questions.
Areshini, thank you so much. We do have a question in the chat that whether electronic incarceration is charged to the prisoner.
No, it's free.
Okay, I do know in many jurisdictions, at least, if a person has been charged with the DUI and they have an auto lock system on their car, that they are charged for that. And I do have a general comment before asking a question. I want to refer back to ACEs, the Adverse Childhood Experiences. And I did post in the chat a link to an exceptional TED Talk about this. And I want everyone to understand that it not only affects an individual incident as it may relate to the criminal case, but it also can change the DNA of the individual, both physically and mentally. And that has a generational impact and consequence. And I know I have seen that in my practice. Areshini, I have a question for you. What are our local facilities? We have the Charlottesville-Albemarle County Regional Jail, and at least fortunate in terms of its geographic proximity, we have the Fluvanna Women's Correction Center. Can you speak briefly about each of those and what they offer, particularly as regards women at the Charlottesville-Albemarle County Regional Jail?
Definitely, and Claire can definitely weigh in on this. So locally, if you are being held pretrial, we have a regional jail, which is a regional jail between Charlottesville, Albemarle, and Nelson County. And so regional jails are common in areas where we don't have, the city of Richmond is larger than we have, so they have an exclusive jail. Henrico is larger, so they're going to have an exclusive one. So people are held pretrial at the jail, pretrial on a felony, pretrial on a misdemeanor. Our jail has nothing to do with being a federal detention center whatsoever. That's completely different. The next level, which is the Department of Corrections. Now, the Department of Corrections, the jail is run by a superintendent. There is a board of the jail. I think you've probably seen that in the newspaper. The next level up for felonies are the Department of Corrections. And the Department of Corrections, one, manages all of the jails. And how someone goes into the jail is that they're sentenced on a felony. It's got to be more than 12 months. So currently, because of COVID, there is no entry into the Department of Corrections, because I think we all realize moving people from different congregate settings, especially with COVID going on, is not a good idea. So right now, there are people at the Albemarle Charlottesville Regional Jail who are serving 3 years or less, the people who are not on the monitor. And that's important because that keeps people in the community, it keeps them close to their relatives or anyone who wants to visit. I do know that because of COVID, our jail has rolled out two significant, interventions. And one is providing everyone with an iPad so that you can have access to program, access to family. And the other part of it is that they have been skilled in terms of vaccination. I would like to just say one little plug for us. There's an article in today's Daily Progress, and we just launched in the fall, or will launch in the fall of 21, this program called Books Behind Bars, which was in the juvenile system for the last 10 years. And we're bringing it, this is the first time, to an adult population at the jail. So that is jail, and that's programming. And there is specific programming in the jail for women. And I'll quickly get to the Department of Corrections. So the Department of Corrections is where you're technically going to be serving more than 12 months on a felony. How you are entered into the Department of Corrections is not geographic. So you don't have to live in Fluvanna. Well, the women's prison is an anomaly, but for male offenders, they are entered by risk because there's a smaller population for women. That is why we have the Fluvanna Correctional Facility. So men are by risk, and it doesn't matter. You could be an offender in Abingdon and they might go put you in Virginia Beach. So that's important to remember as well in terms of families' access to their loved ones. But so those are the two differences between the jails and the prisons.
Thanks, Areshini. We have a couple of questions related to fees. And one would be, what exactly are people who are convicted being charged through fees to pay for? And what is the consequence if they're unable to pay those fees?
The first place I would direct you, Sally Hudson has some really great legislation on this, and Claire can probably talk more specifically about it. But at the step below that, the government regulates courts and fees. And so people are assessed a fee if they are found guilty or they plead guilty. And some of these fees, as you've mentioned, are external fees. So there might be a fee for ignition interlock if you're convicted of a DUI. The other part of the fees are called what are called court costs. And these court costs, I think in the newspapers where people have read about it, there was significant legislation in the federal courts, because if you did not pay your court costs, your license was suspended. Well, if your license is suspended, how are you going to go to work and get a job? And so it became cyclical. So there were many advances in there, thanks to, legislative advocates on that. But besides the point, the fees are assessed by the courts. They can be paid in money, or you can perform community service to do them, or you can get on a payment plan. But the courts don't have flexibility on those fees.
Thank you. There was a question asked about the TED Talk I had mentioned. If you download the chat, it will be there. But if you do a simple internet search, TED Talk, Adverse Childhood Experiences, it pops right up. We're almost out of time. I do want to ask if any of our presenters have any final comments they would like to ask. I'll have a closing remark and then turn it over to Pat Cochran. Yes, Claire.
I have just two comments about things we haven't really talked about but are important. It was some years ago, I did a tour of the regional jail in Albemarle, and the regional superintendent told me at the time, and I don't think there's any reason to think it's different now, that more than 30% of the people in that particular facility were on psychotropic medication. The reality is that our jail system in Virginia is our primary provider of mental health services in Virginia at this point. We criminalize the way people behave so we can put them in jail. We then treat them and then we release them, but we don't release them into communities that have any kind of community support programs. And so they cycle in over and over and over again. And it's one thing that the ACLU and the sheriffs have agreed on, which is that jail should not be our mental health facilities of choice. And I admit when I talk about this that, as a civil rights advocate, having advocated for people to be deinstitutionalized from civil institutions, we didn't do everything we needed to do to make sure that the community services that we said people could benefit from and they didn't need to be institutionalized never really came into place. And the lack of those programs, whether they're for substance abuse disorder or for mental health treatment, the lack disproportionately affects women, but it affects everybody. And that, I think, is something we all have to take responsibility for. The other thing I think we have to take responsibility for is, as taxpayers, we don't like to have general tax revenues assessed against us to pay for public safety. And so as a consequence of that, we have this fee-based system, increasingly fee-based system. So if you ever get a traffic ticket, really parse the ticket. I got a ticket for an expired inspection sticker, $30 for the penalty for the offense, and $60 for the local court court fees and other special local fee for I don't know what. So $90 ticket, $60 of which had nothing to do with punishing me for being a bad actor. That has become the idea that our system should be user fee funded. And that is something that ultimately results in things like the Windsor police policing for profit, so that 10% of the local budget comes from traffic tickets. So I do think those are two things that we need to think about as residents of the Commonwealth in terms of the public policy that affects us and affects this system going forward, and what we're willing to tolerate in the name of keeping our taxes low and not providing the services that we should be providing.
Thank you. And I want to thank all of our presenters here today. We did have a question that asked about how easy it would be for a lot of the progress that we've made in Virginia to be undone. And as this is an event sponsored by the League of Women Voters, if you can read my earrings, and it says vote, and I would encourage everyone to vote every time, every election, because that's how our voices are heard. And with that, Pat, I will turn it over to you. You're muted.
Thank you, Donna. I too wish to thank our speakers. The whole notion of justice reform, especially in the realm of women's justice reform, has really seemed to have, it seems to have developed some teeth in the last year or two in our general society, and I'm really excited about that. And I'm excited that our local league and our state league are interested and studying and trying to learn everything we can about this so that we can better promote good legislation to address some of these problems. And it's through programs like this with Claire Castanaga and Areshini Pather that we can all learn, and there's a lot to learn. And thank you very much. Thank you all for giving up a Sunday afternoon. This was wonderful. Thank you, Donna. Thank you, Kit Murphy McNally. Thank you, everybody, and have a good day.